It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show. Now that I got your attention, I guess I should probably mention I got a new album available now on my site. Nigga, fuck all that whining and bitching. You looking for greatness, then I'm the description. Dropping me by like a prison. Twisting your brow like ignition and split, nigga. That's what I call on the vision. I'm finna infiltrate, you cannot imitate. I'm from a pedigree, this is not Triple H. I took a road, you can't travel like Triple A. Do the impossible, just like a triple play. Genuine energy, I am not Timberlake. But a nigga too insane. Trap for the money, but to pull up in the ring. So I can give a what the fuck about what a nigga think. I'm on some new shit. Elevated my rubric. I'm an industry nuisance, giving my 2 cents. Telling niggas what the truth is. It ain't even about music. Everybody wanna know the cheat code. Bitch, I got bops on reload. I was just on live 2 hours straight. Ain't playing not one repeat song. I'm ready for the spotlight. I was on the block like a stoplight. Every day I catch lightning in the bottle. The niggas told lies, but not hitting spots twice. Couple years I was living on fried rice. Like a tree when I got to eat Popeyes. Gotta beat them, get your whole top five. Spit heat on top like a rabbi. It's no. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well out there this Friday evening. I want to just go ahead and say something real quick, man. I don't know who necessarily comes to this show, this channel, these videos, and sees Inside the Industry on here and expects me to talk about civic affairs like politics and what's going on in office and what's going on from a governmental perspective. I'm going to be honest with y'all, that is not my area of expertise. I have my opinions about these things, but I am not an expert in politics. I am a rapper, songwriter, ghostwriter, music business educator. I've been on panels. I've released books about the music industry. Therefore, this is my wheelhouse. So if you happen to come across my channel and or videos, I just want you to understand, yes, when it comes to the grander scheme of what's going on in the country, music does fall short of, impact in terms of like what Trump and his office are doing, right? But I am not the person to do that. There are a ton of other channels out there that can talk to you all day, all night about that. So I just want you to understand that that's what you're looking for. This is not the channel for you, or at least not for that type of subject matter. But I hope that the information that you get about music news and things of that nature will make you stay and at least say, hey, when I'm done watching Trump news elsewhere, I'll go check out J Nolan. You know what I'm saying? I just wanted to put that quick little disclaimer out there because I've been seeing people saying, well, why are we talking about this? Why aren't we talking about these other things? Because this ain't that channel, okay? Find that channel for you. Now, let's get into Megan Thee Stallion and Milagro. We've been covering this thing the entire time. Of course, Megan Thee Stallion has a lawsuit against Milagro Gramz for defamation, cyber stalking, promotion of deepfake pornography, and some other things. Of course, Milagro has tried to deny said claims. She's also tried to file a motion for this case to be dismissed by the judge. And in the latest update, the judge has denied said dismissal. Now, as you see in the title of this video, the judge has denied those claims and denied the dismissal of this case with minor stipulations. And we're going to go through the filing from the judge. This is the judge speaking. This is not Megan with new allegations. This is not Milagro defending herself. This is a full detailed description from the judge as to why this has been denied and why certain pieces of Megan's lawsuit will continue to stand in court and will be continued to be evaluated in a court of law. Okay, so we're going to go over what the judge states from a legal perspective about how this case will proceed moving forward. So this is not opinion of anyone else. Once again, this is what the judge says about the standing of this case. All right. So United States District Court, Southern District of Florida, Megan Pete plaintiff versus Milagro Elizabeth Cooper defendant. This is from the judge. So they state, order. This cause came before the court upon defendant Milagro Elizabeth Cooper's motion to dismiss First Amendment complaint, filed December 23rd, 2024. Plaintiff Megan Pete filed a response, to which defendant filed a reply. The court has carefully considered the record, the parties' written submissions, and applicable law. For the following reasons, the motion is granted in part and denied in part. Okay? And we're going to get to what's granted and what's denied. Most of this has been denied, as I've already read through it, but I'm sharing it with y'all. Okay? So background. This case centers on allegations brought by plaintiff, a Grammy-winning hip-hop artist known professionally as Megan Thee Stallion, against defendant, an online personality who goes by Milagro Gramz or Mob's World. Plaintiff accuses defendant of engaging in a coordinated campaign of smear and harassment through social media using video, audio, and written posts to cause reputational harm and emotional distress. The allegations are connected to the fallout from the 2022 conviction of Daystar Peterson, popularly known as Tory Lanez, a Canadian rapper and singer who was found guilty of assaulting plaintiff with a firearm following a widely publicized trial. Defendant operates multiple social media accounts across platforms like Instagram, TikTok, X, and YouTube, collectively amassing over 100,000 followers. Plaintiff asserts that defendant has sole control over these accounts and allegedly, under Peterson's direction, uses them to harass and defame plaintiff by disseminating false narratives and conspiracy theories. These include claims that plaintiff lied under oath, suffers from alcoholism, is mentally retarded, and needs a guardian. And just one thing, stuff I've been seeing on social media, it looks like they're trying to reintroduce retard into common language again. I don't know why that's becoming a thing. I've seen like 5 different really large creators, artists, musicians, etc. that are trying to reintroduce that as an insult. I don't know why y'all trying to make that a thing, dog. Let that shit go. But let's keep going. These alleged falsehoods have severely impacted plaintiff's mental health, leading her to contemplate unaliving herself. The Peterson trial. Fully understanding defendant's defamatory statements requires context from Peterson's trial and conviction. On July 12, 2020, a Los Angeles police conducted traffic stop involving Peterson and plaintiff following reports of gunfire in the area. During the stop, officers discovered a recently discharged firearm with an empty magazine and observed that plaintiff had sustained injuries to her feet, later confirmed as gunshot wounds. Peterson was arrested for possession of a concealed weapon, while plaintiff was transported to the hospital for treatment. About a month later, plaintiff publicly identified Peterson as the shooter via social media, leading to his eventual indictment on charges of felony assault with a firearm, illegal possession of a firearm, and negligent discharge of a firearm. If you don't understand what that means, rewind the video back 3 times and listen to it. During Peterson's trial, plaintiff testified for the prosecution, recounting the night she was shot and the trauma it caused in her personal and professional life. She recalled stepping out of the car, at which point he raised a gun, shouted "Dance B," and fired 5 shots, injuring her feet. Okay? Plaintiff also revealed that the incident and her decision to testify sparked backlash from parts of the music industry and online supporters of Peterson during the trial's media coverage. 10 days after plaintiff's testimony, Peterson was convicted on all charges and sentenced to a 10-year prison term. Harassment campaign. Defendant allegedly attended the entire trial. During and after the proceedings, defendant, purportedly on Peterson's payroll and acting at his direction, launched a smear and harassment campaign against plaintiff on social media. This campaign included the use of bot accounts to flood plaintiff and her supporters with hateful, derogatory, and malicious statements. On one occasion, defendant even called for violence against plaintiff. The overarching goal, per plaintiff, was to maliciously injure her reputation and inflict severe emotional distress upon her. Plaintiff asserts this effort was retaliation for her testimony against Peterson. In executing the smear campaign, defendant allegedly made several defamatory statements, which plaintiff categorizes into 3 main accusations. Plaintiff lied under oath during Peterson's trial. She's an alcoholic and she is mentally retarded in need of a guardian. These are the claims made by Milagro that they're referencing. Plaintiff asserts these statements were made with actual malice, as evidence disproving them was widely available at the time they were published. Deepfake video. Defendant allegedly took her harassment a step further by promoting a deepfake Pinot video depicting plaintiff. Defendant on her mobsworldx.com account liked a post featuring the video and then directed her followers across social media and anyone who saw her post to browse her then public likes page. Plaintiff insists this was done to amplify the video's reach. Plaintiff's claims. On December 10th, 2024, plaintiff filed her amended complaint alleging defamation per se count 1, promotion of an altered sexual depiction under section 83613, Florida statute count 2, intentional infliction of emotional distress count 3, and cyber stalking under section 7840485, Florida statute count 4. In response, defendant brings the present motion seeking dismissal of the amended complaint in full for failure to state claims for relief. Legal standard. To survive a motion to dismiss under Federal Rule of Civil Procedure 12b-6, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. So now the judge is telling us, the legal standard as to how this type of claim can survive, meaning it would be upheld by the court, right? Although this pleading standard does not require detailed factual allegations, it demands more than an unadorned, the defendant unlawfully harmed me accusation. Pleadings must contain more than labels and conclusions, and a formulaic recitation of the elements of a cause of action will not do. To meet this plausibility standard, a plaintiff must plead factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. The mere possibility the defendant acted unlawfully is insufficient to survive a motion to dismiss. When considering a motion to dismiss, a court must construe the complaint in a light most favorable to the plaintiff and take its factual allegations as true. Okay? Discussion. Defendant raises 5 grounds for dismissal. So the defendant, of course, is Milagro. She has 5 grounds that she's pleading to the judge to say this should be thrown out. First, defendant contends plaintiff failed to provide her required pre-suit notice for her defamation claim. Second, defendant argues her statements are not actionable, and even if they were, plaintiff has not alleged actual malice as required she do for public figures. Third, defendant claims plaintiff has not adequately alleged that defendant promoted the deepfake video. Fourth, defendant asserts that plaintiff's allegations are not sufficiently outrageous to sustain on an IIED claim, and I think that's the intentional infliction of emotional distress. Fifth, defendant insists that plaintiff has not complied with the statutory prerequisites for her cyber stalking claim. Defendant also asked the court to strike some of plaintiff's requests for attorney's fees. Plaintiff opposes each of defendant's arguments. The court considers the arguments in turn. A. Pre-suit notice. Defendant begins by asserting that plaintiff's defamation claim in count 1 should be dismissed due to noncompliance with Florida's pre-suit notice requirements. As relevant here, section 770.01 Florida statute states, before any civil action is brought for publication or broadcast in a newspaper, periodical, or other medium of a libel or slander, the plaintiff shall, at least 5 days before instituting such action, serve notice in writing on the defendant specifying the article or broadcast and the statements therein, which he or she alleges to be false and defamatory. Okay? The parties dispute whether defendant qualifies as a media defendant. Based on plaintiff's well-pleaded allegations, the court concludes she does not. Ooh. Interesting. So the court is saying that Milagro does not qualify as a media defendant. Damn. To determine whether a party qualifies as a media defendant, courts assess whether the defendant's function is to inform and initiate uninhibited, robust, and wide open debate on public issues. Simply put, media defendants are those engaged in the dissemination of news and information through the news and broadcast media. Some Florida courts have applied this exception to so-called blogs, which are a modern functional equivalent of traditional news media. So-called blogs, that's kind of crazy. Defendant styles herself a blogger who reports on various pop culture items, not just plaintiff. Plaintiff's allegations, however, which the court must accept as true, paint a different picture. Plaintiff claims defendant is a longtime mouthpiece for Peterson. Defendant engaged in a concerted effort to harass and discredit plaintiff on his behalf. Nothing about this alleged conduct suggests an effort to impartially disseminate information, meaning there's nothing objective about what she does. According to plaintiff, defendant has even publicly admitted that she is not a journalist. The allegations thus depict a campaign, not journalism. Oh, shit. And the court cannot find that defendant is a media defendant entitled to protection under Section 770.01. For those of y'all that listen to Milagro, this is what she not going to tell y'all. B, defamation per se. In count 1, plaintiff alleges defendant defamed her through 3 distinct assertions. 1, that she lied under oath during Peterson's trial. 2, that she is mentally incompetent and requires a guardian. And 3, that she is an alcoholic. The statements as alleged by plaintiff are reproduced below. Okay? So now they're putting quotes from Milagro, that Megan has turned into the courts to say these are some of the defamatory claims that are, that have been produced by Milagro. So accusation of perjury. This is a quote. This is Milagro. At the end of the day, a bitch lying on somebody is low down. Yes, she got hurt and that's cool, but how did you get hurt? Right? We've talked about these quotes numerous times. I'm not going to go through all of them at this time because that would just draw this out further than needed. But y'all know the claims. Right? Accusations of mental incompetence. She says, let me go find a receipt of Megan's ex-bestie telling me she wasn't fucking T. Ferris. That's her guardian. She says, okay, so back in 2020, I'm doing what I do now, and a rumor was circulating that plaintiff was fucking T. Ferris. I reported on it, and since old girl and her friend's family watched my show, one of her besties that I had an internet rapport with hit me. As you can see, she said it was not possible for plaintiff to be sleeping with T. Ferris because he was her guardian, like a father figure. I thought the verbiage was odd, but as time went on, I realized plaintiff, as in Megan, was slow and needed one, so it made all sense then. Okay? Then the accusations of alcoholism. She says, you ought to be somewhere for your alleged crimes, drunkie. Why do you even speak? Like, does your liver even function well? When you have drinking seemingly running through a family, yes, I did post certain questions to my page. Yes, I did. Plaintiff comes from a family of alcoholics because the fact of the matter is you have a grandfather that was an alcoholic. Your daddy on drugs? Was he in and out of the system? What was that for? Do you want to talk about that? Is stealing worse than drugs and ish? Okay. They say to state a defamation claim under Florida law, a plaintiff who is a public figure must allege 1, publication, 2, falsity, 3, actual malice, 4, actual damages, and 5, the statement was defamatory. Defendant asserts that this claim fails because the alleged statements amount to opinion or hyperbole, and plaintiff does not adequately plead actual malice. So let's get into opinion or hyperbole. Under Florida law, a defamation claim requires that the statement at issue be reasonably capable of a defamatory interpretation. This determination is to be made by the trial judge in the first instance prior to the jury's evaluation. A court should assess the relevant statement through the lens of how a reasonable person would interpret it, taking into account the circumstances in which it was expressed. An opinion is incapable of being true or false, and therefore cannot be defamatory. But when an opinion implies undisclosed defamatory facts as its basis, it still may be actionable. So it's one thing to say, this is my opinion, I believe this to be, versus making a claim that what you're saying is true, even though it may be your opinion. Okay? They say, like an opinion, hyperbole is not actionable as statements that cannot reasonably be interpreted as stating actual facts about an individual cannot be defamatory. Okay? Perjury. Defendant characterizes her statements in the perjury category as mere assessments of plaintiff's credibility as a witness in Peterson's trial, and argues that even if the statements amounted to an accusation of perjury, they remain non-actionable as opinion or at worst hyperbole. She maintains that such criticism and disagreement with a jury's verdict is natural, and that her statements framed as calling plaintiff not credible rather than a liar fall within that discourse. Okay? Alternatively, defendant claims that her statements were substantially true and thus not defamatory. Plaintiff insists that defendant's statements were false factual assertions, while emphasizing that courts have constantly treated perjury accusations as verifiable statements. Plaintiff's allegations, taken as true, indicate that defendant was not merely opining on the jury's verdict or plaintiff's credibility. She accused plaintiff of perjury, calling her a lying ass hoe who ruined Peterson's life and questioning whether she was caught trying to deceive the courts again. Given the context of Peterson's trial, a reasonable person could view these statements as factual assertions about plaintiff's testimony rather than mere opinion. The judge is flaming your ass up on the low ski, ma'am. Okay. Let me go down here because I'm going to go past these legal references. But here it says, noting phrases like I believe or I think are classically indicative of opinion, right? So you would typically have to preface your opinion with something like I believe or I think, or this is my belief, or something to that effect in order to assert opinion versus factual allegations of falsity, right? Nor can defendant's statements be dismissed as mere hyperbole because accusing someone of lying in court is not exaggerated rhetoric. It is an assertion of fact that can be disproven. At a minimum, a reasonable person could interpret defendant's statements as factual claims about plaintiff, and in this context, there is simply nothing hyperbolic about an allegation of perjury. Defendant also attempts to recast her statements as substantially true by attaching live stream transcripts and X.com posts to her motion offering alternative, potentially non-defamatory interpretations. But these materials are not properly before the court. While the incorporation by reference doctrine allows the court to consider documents attached to a motion to dismiss, that exception applies only if the document is referred to in the complaint central to the plaintiff's claim and undisputed, meaning its authenticity is not challenged. While plaintiff maintains certain X.com posts and live streams in her amended complaint, she does not reference the specific portions defendant now seeks to introduce. Nor does the court find that these materials are central to plaintiff's claims in the way defendant suggests. In any event, plaintiff disputes the authenticity of the transcripts, and understandably so, because they were generated by artificial intelligence and supported by unsworn declarations, which ends the court's inquiry. Because remember, Milagro came to the table with transcripts of things said on social media that were produced by AI, and they put it in their filing to let it be known that they used some sort of AI program to transcribe everything. And Megan says, we can't trust that AI shit, right? As for the X.com post, defendant provides no accompanying records and ultimately offers nothing for the court to verify their content or authenticity. Even if considered, these materials do not establish that defendant's statements were substantially true. The substantial truth doctrine does not defend perfect accuracy, only that the gist or sting of a statement be true. Before reaching that analysis, however, the threshold question is whether the statements are capable of a defamatory meaning, an issue of law for the court to decide. At most, defendant's explanations introduce ambiguity, precisely what precludes dismissal. If a statement is revealed to be confusing or ambiguous, raising the question of whether listeners might have heard it in a defamatory way, a jury question is presented. Asserting defendant statements that plaintiff just does not tell the truth stem from a past relationship between Peterson and plaintiff, alteration added. For example, defendant contends that the question, was Megan caught trying to deceive the courts again, is not defamatory when viewed in full context. The full statement reads, was plaintiff Megan caught trying to deceive the courts again? The answer is yes, if you ask her former cameraman, Emilio Garcia. After Garcia filed a lawsuit alleging an unstable work environment, Megan Thee Stallion filed to dismiss the lawsuit brought against her with the potential to have the case refiled in New York. The thing is, Garcia is calling bullshit and says plaintiff is lying and lives in California. He has hotel receipts, tests, emails. Okay? The judge says, but context does not eliminate the ambiguity inherent to the initial question. Is yes affirming that Garcia believes plaintiff was trying to deceive the courts for a second time? If so, defendant's question could imply that plaintiff previously deceived the courts when she testified at Peterson's trial. Or is yes merely a statement of Garcia's opinion, which defendant is relaying? The ambiguity matters. If a statement is susceptible to both defamatory and non-defamatory interpretations, the court cannot resolve the issue as a matter of law. Defendant's explanations do not erase the potential defamatory meaning of her words, and thus the court cannot deem them non-actionable, meaning that it can't be thrown out. Right? So they just got to figure some things out on that one. Now, mental incapacity and alcoholism. Defendant also claims that her statements calling plaintiff legally retard and in need of a guardian are opinion or hyperbole and thus not defamatory. She makes the same argument for her statements that plaintiff is a drunkie or from a family of alcoholics, claiming they too are exaggerations. True vague epithets like calling someone a maniac or an idiot have been deemed non-defamatory opinion. But defendant's statements go beyond casual name calling. She allegedly asserted or implied that plaintiff is legally incapacitated, requires a guardian, and suffers from alcoholism. As plaintiff notes, legal incapacity is a verifiable fact. So if there was anything that would suggest Megan was mentally incapacitated or delayed, there would be some form of proof. They say finding that accusing a pilot of paranoia was not pure opinion, but rather a defamatory allegation of a mental affliction. Likewise, Florida courts have long recognized that falsely labeling someone an alcoholic can sustain a claim for defamation per se. Okay? To be sure, the nature of online discourse can encourage an outspewing of thoughtless rhetoric, but the court cannot conclude as a matter of law that defendant's insults amount to nothing more than crude hyperbole. Given that a reasonable person could interpret defendant's statements as accusations of perjury, mental incapacity, and alcoholism, the court finds they are actionable as defamation, which means that they will be moved forward to be determined at a later time, not tossed. Actual malice. The First Amendment requires a public figure to prove that a defamatory statement was made with actual malice to recover damages. To plead actual malice, in turn, a plaintiff must allege facts sufficient to give rise to a reasonable inference that the false statement was made with knowledge that it was false or with reckless disregard of whether it was false or not. The court's central inquiry is whether the defendant, instead of acting in good faith, actually entertained serious doubts as to the veracity of the published account or was highly aware that the action was probably false. Again, the parties agree, at least for the purposes of the motion, that plaintiff is a public figure. Where they part ways is actual malice. Of course, Milagro does not believe she acted in malice. Megan says, yes, you did, right? So they say, puzzlingly, defendant argues that the amended complaint must establish actual malice by clear and convincing evidence, and failing that, plaintiff's defamation claim must be dismissed. But the very case defendant relies on proves otherwise. At the motion to dismiss stage, a public figure need only plausibly allege actual malice under Iqbal and Trombley, which I'm guessing is an old case reference. The amended complaint makes a compelling case that the defendant acted with reckless disregard for the truth. Once again, they on your ass. They say you moving with reckless disregard for the truth. First, plaintiff asserts that readily available information contradicted defendant's statements at the time of publication. So they say here in the amended complaint, which was filed by Megan, they say noting defendant insisted that plaintiff is Megan, had never been shot despite medical evidence of bullet fragments showing otherwise. Second, plaintiff alleges defendant knowingly spread these falsehoods at Peterson's direction, fully aware they were fabricated to harm plaintiff. Third, plaintiff contends defendant's actions were driven by pure hatred. Alteration added, blah, blah, blah. Finally, defendant seemingly profited from the defamation. So they say you making money off of these knowingly false claims. Okay? Gaining a larger social media following, online notoriety, and lucrative sponsorship opportunities. Defendant downplays these allegations, arguing that spite and a failure to investigate do not establish actual malice. But plaintiff's claims extend far beyond mere negligence. They paint a picture of an intentional campaign to destroy her reputation that is more than enough to satisfy the pleading standard. Ooh, shit. C. Promotion of an altered sexual depiction. Count 2. Under Section 83613 Florida statutes, a plaintiff may bring a civil action against anyone who willfully and maliciously promotes an altered sexual depiction of her without her consent. The statute defines promote broadly, covering actions like publishing, distributing, exhibiting, or presenting the altered content. Count 2 of the amended complaint alleges defendant did just that. First, by liking a post on X.com containing a deepfake porn video of plaintiff, then by directing her followers to her likes page where the video remained accessible. The parties do not dispute that the video meets the statute's definition of an altered sexual depiction, meaning that they both agree that this was fake. They only disagree on whether defendant's conduct amounts to promotion. Right? So we get into the definition of what promotion is. The court finds little precedent directly interpreting Section 83613. Thus, it looks to dictionary definitions for guidance. Okay? Here, the statute itself provides direction as it defines promote to broadly include actions such as exhibit and present. Exhibit means to present to view. And present means to bring before the public or to one's attention. Defendant allegedly did both. Oh, shit. By liking an X.com post that featured the deepfake video, the video was exhibited on defendant's X.com account's likes page, which tracked and displayed like posts for others to see. Defendant also brought the video before the public when she allegedly directed viewers of her post to click on her likes page where the video had been archived. They say defendant intended for this statement, go to my likes, to encourage her followers and other members of the public to watch the deepfake video, which had been added to her likes page around the same time. Because plaintiff plausibly alleges defendant promoted the deepfake video under Section 83613, dismissal is unwarranted, meaning not gonna happen. So now we get to D, intentional infliction of emotional distress. To state a valid IIED claim, a plaintiff must plausibly allege the following 4 elements. 1, the defendant's conduct was intentional or reckless. 2, the conduct was outrageous. 3, the conduct caused emotional distress. And 4, the emotional distress was severe. Defendant argues that her purported conduct was not sufficiently outrageous to support an IIED claim. She insists that the allegations involve mere words and opinions rather than threats, assault, or other extreme behavior. They say the standard for outrageous conduct is particularly high in Florida. Outrageous conduct is usually something more than sexual discrimination or sexual harassment. So these are cases that they use as examples. As the Florida Supreme Court has explained, liability attaches only where the conduct has been so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Whether a claim meets this threshold depends on the sum of the allegations in the specific case at bar. As a threshold matter, defendant is mistaken in asserting that plaintiff has failed to allege a threat of physical violence. They still on your ass. The amended complaint states that defendant threatened to slap plaintiff in retaliation for her testimony against Peterson. Of course, Peterson is Tory. Remember, she said she was going to slap her for fucking with her nigga. Okay? More significantly, the court declines to dismiss the IIED claim for 2 reasons. First, when viewed in context, defendant's alleged conduct plausibly meets the extreme threshold for outrageousness, particularly given plaintiff's vulnerable mental state. A summary makes this evident. According to the amended complaint, Peterson shot at plaintiff's feet while shouting "Dance B," injuring her. At Peterson's trial, which defendant allegedly attended, plaintiff testified about the shooting and described the lasting trauma she endured. After that, the defendant allegedly aligned herself with Peterson, launching a campaign of harassment, publicly accusing plaintiff of perjury, calling her a habitual drunk, suggesting she was legally incompetent, and directing followers to a deepfake P video of her. Taken in isolation, any one of these allegations might not suffice. So they say if you had only done one of these things, rather than a tandem and collection of all of these things, then these allegations might not hold up. They say, but taken together and against the backdrop of plaintiff's alleged trauma, including thoughts of unaliving herself following the shooting, the conduct plausibly rises to the level of extreme and outrageous. Wow. So here they say where the alleged conduct on the part of the defendants may not be considered outrageous when the victim is of ordinary emotional and mental status, such conduct may become actionable when the alleged victim suffers from known emotional and or psychological trauma. Second, even if defendant's conduct was not independently extreme, dismissal would be premature given the undeveloped factual record. They say the lack of any record evidence at this point concerning plaintiff's mental state and defendant's level of knowledge about it precludes such an early determination. Because plaintiff's trauma and defendant's alleged exploitation of it are central to the IIED analysis, the court cannot conclude at this stage that the claim fails as a matter of law. Okay, declining to dismiss IIED claim where in the absence of record evidence, the court could not determine whether the conduct met outrageous threshold. So at this time, they say that for the most part, Megan's claims are holding up, but they need further evaluation of her mental state and some records. Okay, but it's not being thrown out. There's just some more information that needs to be evaluated, right? Part E, cyberstalking injunctive relief. Next, defendant contends that plaintiff fails to state a claim for cyberstalking under section 7840485, Florida statute, arguing that defendant's alleged conduct does not justify an injunction and that plaintiff has not complied with the statute's procedural requirements. Defendant also urges the court to decline to exercise supplemental jurisdiction over the claim. Section 7840485-1, Florida statute creates a civil cause of action for injunctive relief from stalking. Stalking occurs when a person willfully, maliciously, and repeatedly follows, harasses, or cyberstalks another person. A separate section of the statute defines cyberstalking more precisely. So here they get into the definition of cyberstalking. To engage in a course of conduct to communicate or to cause to be communicated, words, images, or language by or through the use of electronic mail or electronic communication directed at or pertaining to a specific person. So directed at will mean like you sent it in their direction. Pertaining to is like you're speaking on that person, right? Causing substantial emotional distress to that person and serving no legitimate purpose, right? So you have no reason to be doing this other than to inflict harm upon them in some fashion. Okay? To state a claim under section 7840485 based on cyberstalking, the plaintiff must allege that the defendant willfully, maliciously, and repeatedly engaged in a course of conduct that involved directly or indirectly communicating or causing to be communicated words or images using electronic communications directed at or pertaining to a specific person that caused substantial emotional distress to that person and served no legitimate purpose. Further, to obtain relief, a plaintiff must file a verified petition alleging the existence of such cyberstalking and setting forth the specific facts and circumstances for which relief is sought. Plaintiff argues she satisfies the standard for cyberstalking because she alleges that defendant willfully and maliciously engaged in a sustained course of online harassment, repeatedly spreading defamatory statements, using bot accounts to attack her credibility, and directing followers to a deepfake pornographic video. These communications made through electronic means were targeted at plaintiff and allegedly caused her substantial emotional distress, exacerbating trauma she had already suffered. What's here? Recognizing that cyberstalking is not limited to direct messages or emails. Plaintiff also asserts that defendant's conduct served no legitimate purpose as it was designed solely to humiliate, discredit, and retaliate against her for testifying against Peterson, aka Tory Lanez. Defendant first insists that her statements had a legitimate purpose and that the First Amendment shields her from liability, precluding injunctive relief. The court disagrees. So Milagro tried to use the First Amendment, freedom of speech, to her advantage. The judge says, nada. Sorry. They say plaintiff does not allege mere insults or hyperbole. Rather, she claims that defendant waged a campaign of intimidation and harassment against her. These allegations, taken as true, are sufficient to support plaintiff's assertion that defendant's conduct served no legitimate interest. Defendant next argues that plaintiff's petition for injunction against stalking lacks sufficient factual allegations and fails to meet the statute's procedural requirements. On this point, the court agrees. So Milagro does have at least one piece here that the judge says, I can see where you're coming from, right? The petition merely states, petitioner is a victim of cyberstalking because respondent has committed cyberstalking, and then directs the reader to the amended complaint for further details. This is insufficient. Section 7840485 requires the petitioner to specifically allege incidents of stalking, including when and where they occurred, and to mark applicable categories such as whether the respondent previously harassed the petitioner. The petition offers no such details. A conclusory assertion paired with a reference to an external pleading is not a substitute for a properly sworn statement. Okay? So they say the mere fact that an exhibit is attached to a verified complaint does not mean that the person verifying the pleading adopts under oath all statements contained in the exhibit. They say the petition falls short, lacking the necessary detail and failing to provide a sworn account of defendant's alleged cyberstalking as required by statute. Plaintiff all but concedes the point and indicates she would be willing to swear to the allegations she relied on to cure this defect. Okay? Stating plaintiff would swear to the amended complaint if the court deems that necessary. The court will permit plaintiff to cure this defect. Okay? So here they pointed out an oversight in Megan's petition to the court, right? In her lawsuit. And they say that they have not provided enough specifics that detail specifically to cyber stalking, right? So she's going to have to come back and correct whatever errors they're finding in there, which that's like a moral victory for Milagro. It's not a victory of any kind. The rest of this paperwork states that they disagree with her along the way. This is not getting tossed out, but Megan does have to make some modifications to her claims to move forward. Okay? With this specific piece about cyberstalking. That does not mean that the cyberstalking claim has been dismissed. It only means that it needs to be fixed. Lastly, the court declines to relinquish jurisdiction over this claim because it has no discretion to do so. Plaintiff correctly asserts that diversity jurisdiction applies as the parties are completely diverse and the amount in controversy exceeds $75,000. Excuse me. And we still don't know exactly how much money is being, in pursuit from Megan, but we know it's over $75K. Okay? Defendant's argument that plaintiff's cyberstalking claim alone does not satisfy the amount in controversy requirement misses the mark. The diversity statute governs entire civil actions, not individual claims. So that would mean that the whole thing would have to be proven invalid rather than certain pieces. Okay? The diversity statute provides for jurisdiction over civil actions between diverse parties in which the amount in controversy exceeds $75,000. Other than plaintiff's deficient petition, which she will have a chance to cure, she has adequately pleaded a claim for cyberstalking under Florida statute section 7840485. Interesting. So they still pretty much siding with Megan here. They said, hey, outside of a deficient petition, which she's going to be able to fix, it's still an adequate claim. Now, in terms of attorney's fees, because Milagro doesn't want to have to pay Megan's, they state, finally, defendant moves to strike plaintiff's request for attorney's fees asserted in counts 1, 3, and 4, arguing that no contractual or statutory basis supports such an award. Even if defendant is correct, in federal court, there is no special pleading requirement for attorney's fees. A request for fees is just that, a request. Striking it now serves little purpose. Federal courts generally refrain from pruning pleadings based on speculative entitlement to fees, preferring to address the issue if and when the prevailing party actually moves for them. Should plaintiff ultimately seek attorney's fees, defendant remains free to challenge the request at that time. So they're saying there's no reason for us to strike Megan's request for attorney's fees because we still got to move forward. Like we gotta at least prove that she's gonna win this before we try to say what y'all are gonna be held liable for in terms of fees. So wait it out, and if and when she wins, which she is, you can then contest. Okay? In conclusion, for the foregoing reasons, it is ordered and adjudged that defendant Milagro Elizabeth Cooper's motion to dismiss First Amendment complaint is granted in part and denied in part. Plaintiff Megan has until February 18th, 2025 to file an amended complaint curing the deficiency in count 4, done and ordered in Miami, Florida, this 7th day of February 2025. Okay? So Megan has until February 18th to come back, fix her complaint all over again, just for that section, which is going to be fixed. And then the judge is going to say, we're going to move forward with this case. That's just what it is. The dismissal has been denied. It's going to continue. Megan's going to come back and put her amended complaint in, and the judge is going to push it forward. They're going to have to go to trial. Milagro has submitted a proposal for settlement. I don't think she's going to get it. They're going to have to go to trial. Megan's not letting up on this. So that's where we currently stand as of February 7th in terms of the Megan Thee Stallion Milagro Gramz case lawsuit. Again, if you're going up for Milagro, the judge here is not. There was a minor piece there that the judge said this is insufficient, and they're giving Megan the opportunity to come back and fix it, which means that these counts will be enforced moving forward. That's what it is. They're not going to deny her. Otherwise, if they intended to, they probably wouldn't be giving her an opportunity to change it. Anyway, that's where we stand. Let me know what y'all think of all this down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. Milagro has come out and made some statements. She refuses to go into grave detail, but she's trying to get her people to understand, I guess, a little bit of what's going on. She's kind of lying. She's implying that this that certain counts have been denied. It's not what happened. That wasn't a denial. It was just a, please fix this piece here so that we can accept it. But again, she uses mental gymnastics that works on her audience. But that's not going to work over here. And I'm not saying that I'm like on Megan's team or anything like that, but just as it pertains to pushing out the truth, mental gymnastics will not suffice. All right. I'm going to catch y'all on the next one. Much love and respect, y'all. Peace.
King of my city and cul-de-sac. Coming out swinging like soldier rags. Leading my people like quarterback. Boy, I study this shit, I'm an almanac. Had to get up and grind. Knowledge is booming, I'm here to apply. Came with the chip and the dip, it just single the mind. We finna do more than survive. I need my check. Spinning the block for the Gouda. We hitting the jeweler to flood out the net. We don't do beef for computers, so straight out the sewer. We come when you rest. Niggas be looking perplexed, so keeping my foot on their neck. No map, I trust my gut for the quest. But drama, I'm fully abreast. I was ready for years and they doubted me. All of a sudden they tell me they proud of me. I've been dropping these haters like calories. Cross I'm out, I came back with some boundaries. Stand for my honor, but too raw, no corner. Packing the stick with a drummer. When I catch my bad, won't fumble. I done came too far to be humble.